Hi, everybody. Welcome back to another episode of Immigration Law for Tech Startups. I'm your host, Sophie Alcorn. I'm the founder of Alcorn Immigration Law. We are the leading immigration law firm in Silicon Valley, helping international startup founders from around the world to achieve their immigration dreams in the United States so they have the freedom to build their startups. We support rapidly scaling tech companies, professionals, investors, inventors, engineers, and their families wherever they currently are, whether inside the United States already or in another country. Thank you so much for joining me this week. I am thrilled about this episode of this podcast, and you can also find a video on YouTube. This is all about the return of International Entrepreneur Parole. It is an amazing new program for international startup founders to live and work legally in the United States and build their companies. It's not a visa, it's not a green card, and we're going to talk more about what it is, who qualifies, and how you get it. But let me first talk about where it came from so you all understand how it's both an old program and a new program at the exact same time. So, years ago, when I was a stay-at-home mom in Silicon Valley, jobless and wondering how I could return to the workforce and make a broader impact on the world, I would wash the dishes, look out my kitchen window at this building that 500 startups used to be in, and I would wish that I could be in Silicon Valley. It seemed so close and yet so far away. So this was the time of the Obama administration in the United States. And Obama was a Democrat, but he liked business. He liked tech, he liked California, and he liked startups. So he really wanted to get, well, I don't know how much he really wanted to do it. It didn't end up happening. He liked the concept of a startup visa, and his administration was all about prioritizing healthcare. So a startup visa never went through Congress. But he did do something in the twilight hours of his presidential administration right before President Trump took office in January of 2017. And what that was a regulation, which is not a law. It's something in the United States that the president can create pursuant to the rulemaking authority of the office. So you don't need Congress and the House and the Senate to negotiate on all of the details. The president basically says, I'm the president, Congress made some immigration laws, and now I get to establish rules to enforce them. Now, this is kind of an irony. I was explaining to my kids the definition of the word hypocrite the other day. But one of President Trump's campaign pledges was to stop the abuse of the rulemaking authority of the presidential office and the executive branch. So when he rolled into office, he basically tried to undo as many of the which president are we on? Of the Obama era immigration policies. And one of them that got caught up in this was International Entrepreneur Parole. But he tried to cancel the program too hastily, and I don't know if the Department of Justice attorneys advised him on this properly or not, but there's something called the Administrative Procedures Act, which defines how new rules can be made and how they can be stopped. And basically, if you give the people a benefit, you have to go through a legal process with a notice and comment period and other things to be able to take that benefit away. And they didn't do any of that. So my friends at the National Venture Capital Association. Jeff Farah is their general counsel, and he's amazing. They litigated and they sued the Trump administration in federal court about the International Entrepreneur Parole. And they said, hey, your cancellation was illegal. You can't do that. And the judge agreed. And the judge said, okay, that cancellation was illegal, so it is undone, and the rule still stands. And then where it got left and stuck was that, man, this is like legal history for legal nerds, but I hope you enjoy the story. It'll help make sense for where it came from and how it's all coming together now. So years ago, they finally decided to do the right thing and cancel this program the right way. So they published a rule saying that they were going to withdraw International Entrepreneur Parole, and then that just sat there dormant for years. And President Trump went on to create many more executive orders and regulations in his administration, like that whole thing, tweeting about ending immigration because of COVID, which didn't really happen. But anyway, okay, so I had a feeling that the present administration under President Biden would be more amenable to this program. It is a Democratic administration, which is not typically one that emphasizes business, but they do care about jobs for American workers, and they care about immigrants. So we have been, and if you've been listening to the podcast, you know about this already, but we have been collecting applications for people to test out this rule with us because I had a feeling that there would be some movement here soon. So we're already helping many founders apply for this. And the wonderful news is that the Biden administration formally withdrew the proposed rule from the Trump administration to withdraw the Obama administration rule of International Entrepreneur Parole. So one of my friends was like, oh, so it's like backsies on backsies? I'm like, yes, exactly. So basically, all the cancellations have been canceled, and the thing just stands in its pristine beauty now. So it's back, it's available. This is fantastic, incredible news for startup founders around the world, whether you're in the US or not, whether you've ever had an H-1B working visa or a student F-1 visa or not, doesn't matter. You can still qualify for this program if you meet the requirements. So, what is this program for? What types of companies are eligible? Can you apply? So the point of this program is that the Department of Homeland Security believes that qualified entrepreneurs who would substantially benefit the United States by growing new businesses and creating jobs for U.S. workers, if you're in that category, they believe that you should be able to benefit from all viable immigration options. So basically, if you have a startup that is good for America because it will grow new businesses, it will grow new jobs for Americans and otherwise benefit our economy, then you have a chance at qualifying. You benefit from this program because you can live and work in the United States for up to 30 months initially. So that's a 2.5-year approval period. And there's the possibility of qualifying for a 30-month, another 2.5-year extension as well. And another really neat perk about this is that spouses are eligible to apply for a work permit as soon as you get to the United States. So if you're the crazy founder spouse pursuing this dream and your spouse needs to work to pay the bills and hold down the fort. That's possible. Your spouse can get a work permit. And this is the type of work permit that's unrestricted as to whether the spouse can be self-employed, that's fine, or work for a company, that's totally fine. So it's great. Your spouse will have a lot of work flexibility. So who qualifies? All right, we're going to get into this. Okay, there are about 4-ish main requirements. First requirement number 1, your startup, the legal entity of your company, must be less than 5 years old. So I'm recording this podcast in May of 2021. So if your startup is a corporation in the United States that was formed after May of 2016, that would meet the first requirement. It doesn't have to be a corporation. It could be an LLC. What we see as the trend in the Valley is that most investors are looking to invest in Delaware C corporations, which I did a podcast with a great attorney, Lindsay Mignano, last fall about corporations and setting up the legal entity for your startup. And she goes into all of that in a lot of detail. All right. Next requirement, you as the founder must own at least 10% of the equity or value. I don't know how you got to own at least 10% of the company. Okay. So that means it's great. You don't have to be the majority shareholder. There can be other co-founders. That's fine. You don't have to be like the person who originated the idea. You just have to show that you own at least 10% of the company. So that's fabulous because most early stage startup founders do. Next up, you have to show that your role is central to the startup and you will actively operate it. So no passive investors here. I think the ideal thing for this, and we'll discover more as time goes on and all of these applications continue through the process. But I would say that anybody with a C-suite title in the business should qualify. And what do I say when I C-suite? That sounds like Silicon Valley jargon, and it kind of is. Another variant on it is saying, oh yeah, it's a CXO position. And people are like, what is CXO? So the X is a variable. It's like CEO, CTO, COO, CMO, CPO, marketing, product, technology, executive. There are many types of chief officers in an organization. And I would say that if you have one of those titles, you're probably going to be in a role that would be central and operational in the startup. Are other roles disqualified? No, they're flexible. Maybe it could work if somebody's the president. Maybe it could work if somebody's the vice president. So, it just depends. But a lot of early stage startups do like to use those CXO. Now that I defined it, I can say it. All those CXO titles. Okay, so that was prong number 3. Now, the fourth element is you have 2 options. It can either be option A or option B. So the one that most of my clients will qualify for is that their startup has received at least $250,000 US in investment from qualified US investors. The definition of qualified US investor has to do with this angel or VC being a serial investor and being a United States institution or person. So would a Swedish venture capital fund count? Probably not, but don't lose hope. But it's not the easiest way to qualify. Ideally, we would like to show that you found a famous U.S. angel investor who's already invested in several companies, who's a U.S. citizen. It might work with a green card holder. And then there's some questions too that we're seeing about, is it a U.S. fund? What about the LPs? How do we get the proof that the fund managers are in the U.S.? So we're still working out those details. But the wonderful thing that I love about this, well, no, wait, let me pause and then I'll tell you the wonderful thing I love about this rule. Let me get to 2B first. So 2A was $250K from U.S. investors, but 2B, the other alternative fourth, it's 4A and 4B. I got it wrong. Okay. 4B, I'm just so excited about this whole thing. 4B is that you've received at least $100,000 in government grants or awards. So this could be like an SBIR science grant, for example, or National Institutes of Health, or maybe a state economic development grant. There are many types of government grants. Okay, so just to recap the 4 prongs. 1, startup is less than 5 years old. 2, you own at least 10%. 3, you have a central role and you will actively operate the startup. 4A, you've received $250K from U.S. investors. Or 4B, you've received at least $100K in government awards or grants. Those are the basic criteria. But the other wonderful thing about this rule is that even if you haven't raised that much money yet, there's something else that allows attorneys to submit other comparable evidence. So if that Swedish VC invested $15 million and now you want to launch in the United States, I think we would have a strong case that you qualify. Or if the government of Malaysia gave you a $100,000 economic development grant and now you want to launch in the US, I think we would have strong evidence for you to qualify. Nobody's really done this yet, so we're still figuring it out. I am aware of at least one person in the United States who has gotten approved for this status in the past. And the way the law is written is it's very flexible. They really want to support international startup founders to build companies because they know this is a job creation engine for the United States. And our economy has hit some bumps in the road with COVID. And so anything we can do to create jobs would really be beneficial for this program especially, and the country and the world. And, you know, the startup founders I work with, it's not, I mean, some of them actually truly do think about how they can support the American economy, which is lovely. And others think about how their life-saving technologies can save people, or how they can improve quality of life for people around the world. So all of that is fantastic. One thing that I would caution is standard disclaimer for many of my podcast episodes. Remember that cannabis is still illegal under federal law, even though I'm an attorney in California, and California has some different state laws and some other states do. USCIS does not approve visas or green cards or parole for people to work on projects that are illegal at the federal level. But like CBD and the Farm Bill, that's a different thing. And anyway, there's some exceptions, but I'm not going to get into that here. But we kind of want to make sure that we can, like the smell test. Does your company sound like it's going to be good for America? Probably don't want things related to vices or gambling or, but you know, there's lots of things that people are doing, but let's keep it on the up and up and clean and positive so that you have a really easy chance of getting approved and it's not an uphill battle. All right. So some of the information that you should be prepared to provide when you're going through this process, you know, everybody needs an individualized legal strategy. And some of this is based on where you live, where you were born, what country of citizenship do you have you ever been married, what's your marital status now, have you ever had children, have you ever had visas or applied for a green card in the United States? Did you ever have any immigration challenges at an airport or a consulate or the border? Because sometimes those can affect people into the future. So those are some of the things that we would need to know about you personally to know if you qualify. And additionally, we'll need some information about the company, such as what's the company's name? What type of legal form do you have? When was your company formed? How much equity do you have? What are your titles in the company? All of those certainly help. And then information about the investment you've received. Was it from angels? Was it from VCs? Which funding rounds have you closed? What's your runway? Were you in any startup incubators or accelerators? Did you get money from those? How about any economic development awards or grants that you may have received? So all of that history is important because it really looks different for a company that's brand new and maybe found one angel investor who's invested $250,000 into the bank account, right? That company is in a very different position than one that's, raised $3 million and now is going on to raise $15 million from a combination of angels and VCs, and they set up special investment vehicles to transfer the capital. So lots of variations. This would also potentially work for a later stage startup as well, Series B. I don't know, by the time a startup gets to Series C, the equity might be diluted too much to qualify for the 10%, but might be possible. And so this is all what we determine in a consultation when we talk to potential new clients who want to hire us. And if you're interested in learning more, we do have a questionnaire, and the link is available in our show notes. And so you're welcome to fill that out, and we will evaluate your situation and whether you can qualify now. And if you can't, then we'll try to let you know what might be helpful to change in the future so you can qualify. And we could also explore other types of short-term visas and green cards that people might qualify for. And if you're wondering what those are, well, this is, episode 60 or something of this podcast. So there's a lot of episodes you can look back in to figure out, before the International Entrepreneur Rule, how startup founders were navigating the U.S. immigration process to legally come live and work in the United States, because all of those options are still available and viable. This just might be easier for so many people. So really excited to share it with you. Now, a few other things I wanted to talk about, because we do get a lot of FAQs about this program. One of them is, if I get this, can I still apply for a green card? And the answer is yes, you can. It is totally possible. I think this would be a great start to either an EB-1A Extraordinary Ability Green Card or an EB-2 National Interest Waiver Green Card. I mean, it's fabulous. It's totally in the national interest if you've shown that you have substantial potential for growth and job creation in the United States. Super exciting. It's just so wonderful. I've been waiting for this moment for so many years. I think knowing that this program was in the works was one of the reasons that inspired me to start Alcorn Immigration Law and inspired the focus for this podcast, Immigration Law for Tech Startups. I've been following this on pins and needles for the last several years. So I'm really, really, really excited about it. Okay. And just, do you have to technically meet all the requirements? No, you can partially meet the finance requirements, and then we just have to show additional reliable and compelling evidence of your startup entity's substantial potential for rapid growth and job creation. So those are cool. Other FAQs that we get are, what is parole and how is it different from a visa? Okay, so parole is not the thing where immigration parole is not the same thing as jail parole for prisoners, where they're like let out and then there's like a parole violation. Probably in the arcana of legal history, it is the same root word, but it has a very different meaning in the immigration law context than the criminal law context. My understanding of this term, well, first of all, let me just clarify, it's not a real visa. You do not get a multiple entry visa. You get pieces of paper, and those papers, those parole documents, let you into the United States. And so you cannot get parole when you're currently in the United States. So if you are, you have to leave and then come back in. You can do that at a land border by showing the parole paperwork. But if you need to board an airplane or a ship, if you wanted to go on a ship to get to the United States, you would have to go to your home country's consulate or embassy to apply for something called a boarding foil, which is sort of like a visa, and it is an indication to the shipping or airline company that they're not going to get in trouble for letting you on the flight, because you're allowed to board the vessel to be transported to the United States, because you're probably going to be let in with the parole paperwork when you get here. So that's technically how it works. The reason they call it parole is because it's not actually admission. This is like a legal technicality, but the history of parole in the immigration context, I think of somebody like my ancestors went on a boat from Italy to Ellis Island in New York, and they were on Ellis Island and they were waiting to be admitted to the United States as immigrants. And parole would be like, they're on Ellis Island, they haven't been admitted yet as immigrants, but somebody got sick and needs to go to the doctor in New York City. And so they're paroled into the country temporarily for a specific purpose, but then they're supposed to leave and wait to actually be admitted as an immigrant. So it's kind of the history of it. That's at least how I think of it. Okay. Somebody wanted to know, if I have International Entrepreneur Parole, can I do a change of status to an O1A, or can I get a green card? Yes, I think this would be possible. How does the work level of applying compare to that of an O1? Our experience so far is there is a lot less time and energy burden on our clients to gather the necessary evidence that we will need. Many have been just giving us access to their virtual data room that they have prepared for investors, and many of the documents are already in that. Somebody else wants to know about the timing, and we're still waiting to see what the USCIS adjudication period is, but I'm hopeful that for the founders we've already started supporting, they'll be able to move to the United States way before the end of 2021, which is exciting. How does this compare to an O1A and an H1B? Well, it is a self-petition. You do not need to have a company sponsor you. You don't need an agent. You've heard me talk about this in the H1B episodes. Nobody needs to be able to hire and fire you and control your employment here. So that's really good. There's no requirement that the company has to be able to pay a prevailing wage. And so there's no minimum wage like an H-1B. That's assumed through the capital raise that you have the necessary funds. And we also don't need to prove that you have a minimum equity share, a minority equity share in the company, so that there is board control. So those are really, really wonderful differences between some of the other visa types. Next question, do I need a work permit? Nope, you just have your parole documents, and that's legally sufficient. What else? Somebody wants to know if it would affect their current status of changing from OPT as an F1 student to STEM OPT if they're already in the United States. But no, parole only gets activated if you physically depart the U.S. and re-enter intentionally, showing that paperwork. So I believe it will not have any effect on the H-1B. And then somebody else wanted to know how to handle it if they're the founder of a company and maybe their H-1B is at the current startup, but for like a technology manager role and they're an employee, should they change? Well, it might be great to change if you want to switch roles to be the CEO. This would be easier than trying to get an H-1B as a CEO. And if you want to buy back some of the equity or receive some of the equity from other holders and you want to probably go back to a majority share, this could be a pathway to do that as well. And it's always forward looking. So your job doesn't need to change until you re-enter on the approved parole. It's just super exciting. I love this program. I mean, I hope one day that we're still going to have a startup visa too, and that would be similar. And that's the one that I got to help edit for a member of Congress recently. So I'm also still very hopeful that that will become a law sometime in the next couple of years. But that's the long game. And in the meantime, I am just so delighted that parole is active and available for startup founders from anywhere in the world to start using now. So definitely contact us if you're interested in learning more. We do have this questionnaire you can fill out, and that is the first part of our screening process to make sure you're eligible. We would love the opportunity to support you, and you can check out the show notes for that link. So thank you so much for tuning in for this week's edition of Immigration Law for Tech Startups. And subscribe, rate, review, but most of all, please share the love by sharing this great news with a startup founder in your life. So thank you so much, and we'll be back with you soon. Bye.